Welcome to a Practice Pro CPD, brought to you by LAWPRO.
Good morning, everyone. I'm Joan Rataic-Lang. I'm the Executive Director of the Toronto Lawyers Association. Welcome to Succession Planning for Your Legal Practice. The TLA is thrilled to be involved in partnership with LAWPRO to bring these important presentations to lawyers across the province. We started this during COVID. Technology proved that we can bring people from north to south, east to west, all together in one place. And we are excited to be a part of this very important venture. If you're interested in a little bit more information about the Toronto Lawyers Association, you can check our website, become a friend of the TLA, and follow what we do aside from our partnership with LAWPRO. I'm now going to turn it over to Sean. I know that it's a very full program, so hold on to your seats because lots of good information is coming your way. Have a good program, everyone.
Thanks so much, Joan, and thank you everyone for joining us today. My name is Sean Erker. I'm the legal writer and content manager at LAWPRO, and this is part of our ongoing series of Thursday Tips with the TLA. This particular program is called Succession Planning for Your Legal Practice. Now, I'd like to acknowledge right off the start that the offices of both LAWPRO and the Toronto Lawyers Association are located on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. It is now the home to many First Nations, Inuit, and Métis peoples. Toronto is covered by Treaty 13 with the Mississaugas of the Credit. And as this meeting is virtual, we're not all gathered in the same place. I would encourage you to research the land acknowledgement for your particular territory. And one good resource to find out about the history of your land is the website native-lands.ca. And at that website, you can search for your location and find the appropriate territory acknowledgement under the resources tab. So I'd like to just recognize the long history of all First Nations in Ontario and the Métis and Inuit people. We thank the First Nations who live on these lands and lived on these lands and for sharing them with us. So this program is, as Joan said, going to be quite packed. So I want to make sure we get to it as quickly as possible. We will be holding about 10 minutes at the end for questions. We may not be able to get to every single question, unfortunately, and so we apologize, but we will try to cover the key ones, and hopefully we will be able to provide some resources or contact information where people can otherwise reach us. This program is good for 90 minutes of professionalism, CPD, with the Law Society, as well as a risk management credit, which is good for $50 off your LAWPRO insurance for the future. The materials are available in the chat function. You should have received them in an email. If you did not, or if you do not have access to them, you can click on the link in the chat function. There is a second link for Catherine Pretty's presentation where you can find her contact information and the materials for her presentation as well. And you'll be able to find a video of this program online at practicepro.ca/CPD. It will be up within the next week approximately. And these videos of all of our previous CPDs are also available there, so you can watch them on demand at your convenience. Just as a reminder, if you do have a question, please put them in the Q&A chat, not the chat function. There's a Q&A button that will open a separate box where we will be able to track the questions and kind of distribute them at the end. So just as a brief description of what we are going to be covering today, we have some very excellent speakers. We are joined by Ray Leclerc, who is the Vice President of Public Affairs at LAWPRO, Greg Kells, who's a business broker of record and the owner of Sunbelt Mergers and Acquisitions, Catherine McKay-Pretty, who is an insurance advisor at Lawyers Financial, and Anurag Gupta, who is a business and tax lawyer in Toronto. So the material that we are going to be covering is, at first, we are going to be hearing from Ray about the process of wrapping up and closing your practice, what that entails, and the key steps that are involved. Then we're going to be having a conversation between myself and Anurag about what you can do to organize your practices and the files to make it feasible for someone else to step in and manage those files and take key steps. Because the big two questions that we're going to be covering in today's program are: how do you prepare for your planned succession, and how do you prepare for your unplanned succession? And so planned succession are things like retirement, or if you're going to be leaving your private legal practice for another opportunity where you have to pass your clients off to someone else and wrap up your files. But we also need to consider unplanned succession. And that's things such as the proverbial if you got hit by a bus, but also it is just any kind of illness or contingency that might prevent you from assisting your clients and might require you to have someone else step in and take over your files on a very short notice. Now, we're also going to be hearing from Greg Kells, the business broker, about selling your law firm and what goes into that and valuing it as an asset. And then finally, we're going to be hearing from Catherine Pretty about the financial instruments and insurance products that you need in order to prepare for both those planned and unplanned absences from your practice. So without further ado, I just want to pass this off to Ray, who's going to be talking about his own personal experiences wrapping up a practice and what that entails. Ray?
Good morning, everybody. Thank you, Sean, for the invitation. Having gone through the exercise of buying and selling, I think is why I've been asked to provide my perspective to start this presentation and give some context to what we're reviewing. I thought I was an organized person, but just like if you've ever moved your office, you'll find there are numerous things that we did not anticipate, didn't have a plan for, and we have to plan and execute on the fly. I did change law firms twice. I set up 2 different law firms or law practices. And I then sold my private practice to go in-house with a company. So I've had that opportunity to go through that experience a few times. Leaving a firm is a simpler than selling your practice. The firm generally has somebody that will take over the firm client's files. So drafting a transfer memo of the status of the file, the next steps and highlighting any deadlines is time consuming, but less cumbersome of a process. Closing your office and selling your files to another lawyer is a different, in a different office, involves much more effort. There is the transfer memo, of course, to be done, but then you need to physically pack those files, you move those boxes, you need to track what went where, and for when you get the inquiry later about that file, and you will. There is a question of how to advise staff, advise clients and suppliers. Advising staff is a delicate matter unless you have a placement for them to consider. The timing of advising them becomes critical. You need to provide them sufficient time to find alternative employment, or you're going to be paying them a severance. But then the news of the closure can be released prematurely if they discuss it with others. And of course, you run the risk that they may leave for the new job before your closing process is completed and leave you much more work. Advising suppliers is much easier, simply a matter of paying the last invoices, providing them with a forwarding address for any outstanding matters, assuming that you're not tied to any long-term agreements. That is where planning your closing is important to align any ongoing obligations with your termination date. Advising clients requires a discussion with the lawyer buying your practice. Are you going to do a joint announcement? Are you going it alone? Will you be mailing, emailing, or only online notices? Again, timing is crucial because if the word gets out too early, you may lose work until your closing date. Also, the method of disclosure can be critical depending on what you hope happens to the files. If your sale price is based on files being transferred to the purchasing lawyer, you want to approach clients with the best method to get them to accept your suggestions and feel comfortable with that new lawyer. This will require for some clients to be contacted personally by phone or in-person visits, and all, of course, should get some kind of written communication. Be prepared for many calls from disappointed clients, and I guess that is a good sign if they're calling you disappointed that they're not going to be their lawyer going forward. But have the information on the lawyer taking over to reassure your clients that they will be in good hands and that you have considered the matter. It reinforces your recommendation. Setting a date for the turnover is a matter to be negotiated again with the purchasing lawyer and with your clients. A target date puts everything in focus as to what has to be done when. Depending on the new commitments you might have, a flexible date may be possible, or there may be a transition period. I advise clients of my move and still have received calls, email, and emails years later from clients. In fact, I just received one last week after being with LAWPRO for 15 years and out of practice before that. I reminded the client that I was no longer in practice. We discussed options for their issue without me providing them any advice, and directed them to the purchasing lawyer or giving them other names to contact. So you need to be prepared for that, for those calls also. Organization is important. First, to get you through all that needs to be done. When you cut the services, what's the status of your premises? If you have a lease or some kind of other arrangement. I found that creating a checklist or a to-do list lessen the stress involved and organize the move that I had to do. If you have a customized file system, you can help build those matters which are outstanding or which you're not completing before the transfer. Help identify the files that you need to be closed or transferred. You need to send final reporting letters to clients whose matters are completed or decide not to follow your suggesting going to the transferred lawyer. Most important, you need to highlight any pending steps, limitation periods, any crucial matters so that you're not faced with a claim later by the client who missed such a critical matter in their file. It's also critical to create and maintain a list of what happens to what files. What do you do with closed archive files? Sometimes it's part of the transfer that you're sending over to the other lawyer, but it's still important to have a complete list of all of those files that you did send over to that other lawyer. If you're retaining closed files and archive files, again, you want to create a list of those files, but also very important to set up time as to when you can destroy those files. You don't want to be hanging on them forever. Follow a retention policy. LAWPRO will be coming out shortly with some new material on retention of files. On the professional liability insurance side, in moving from a firm to my own practice, I simply needed to advise LAWPRO of the move, my new contact information, and I had my primary first $1 million coverage. You need to consider at that point, though, if you need any excess insurance. I did have, when I left my the law firm and create my own, had worked on files over $1 million. And so I opted to get the excess insurance, again, easily obtainable from LAWPRO. If you're moving to another firm, you need to discuss how your insurance coverage will continue. Does a new firm insure for excess? Does it cover past files that you did while you were at another firm? Does the old firm provide coverage for files while you were with them? Important questions to be able to be asking and to get the right information to make sure that you have the coverage that you think you should have. The Law Society, you need to inform them of your contact information with the Law Society and LAWPRO, because other lawyers will be looking through the Law Society law portal to find you and possibly clients also. One thing that I've noticed is that it's much quicker to, some are much quicker to assess liability to a lawyer who left the firm than those who are still with the firm. So it may be important to retain some information and documentation on files you suspect might suspect some issue in the future, or if you have a need to report the matter to LAWPRO. So be advised. I had purchased two practices in my career. I sold my private practice. I was surprised by the lack of resources for small business for guidance on pricing, sale vehicle, etc. I negotiated as best I could, honored my purchase agreement, however, not so lucky on my sale agreements. I sold on the basis of percentage of future billings and included an audit provision, but eventually I decided that life was too short to audit for lack of payments. So I'm very much looking forward to Greg's presentation on how to prepare for a sale. With that, Sean, I turn it back over to you.
Thanks, Ray. And so moving on, I think the big topic that we need to talk about here is not just the planned sale of a business, not just the planned retirement, not just the planned wrapping up of a business, but also the unplanned wrapping up of a business. So I'd like to invite Anurag up onto the screen to join me, and we're going to have a bit of a fireside chat conversation here, kind of just to talk about his experiences preparing his practice for any eventuality, including both circumstances where he has to leave on very short notice, or circumstances where he has to leave on absolutely no notice, these emergency circumstances. Just to start off, I do want to acknowledge that the LSO is currently going through a review process for contingency planning and succession planning. And that review process in 2022 involved a report from the Professional Regulation Committee, which discussed the possibility of having mandatory succession planning. That went through a public consultation process, and it is currently under review at the LSO. So it is possible, although we don't have a final information for you at this time, it is possible that in the future, succession planning will be mandatory for all insureds. But even if it is not mandatory, it is still highly advised, because from LAWPRO's perspective, not having succession planning in place is asking for malpractice claims, because the circumstances in which you are injured, you are sick, you are unable to tend to your files, and you do not have a plan in place for what happens when that occurs, means that files are going to be left unattended, and timelines can pass, deadlines can pass, important matters can be missed. And so right now I'm going to introduce Anurag again, and I'm going to ask him from his perspective, why do you believe that it is important for lawyers to plan for any kind of potential absences?
Thanks, Sean. Good morning, everyone. So as lawyers, that no matter what area of law that we're practicing in, we always tell our clients that you should have a game plan, whether you're preparing for trial or you're doing a business acquisition. Same thing for lawyers. We need to have a game plan in the eventuality if something happens to you, whether it's a temporary disability or permanent disability or permanent like death. And I think in having one allows your clients to make sure that there's continuity, there is a streamlined process in place, as well as the fact that you know that even if you are in a temporary position where you're disabled, you know your clients have been taken care of.
So, Anurag, I have a question for you.
Yeah.
One of the things that can occur if you are suddenly, for example, hit by a bus, is the LSO can step in with trustee services who will be able to come in and manage your files and bring in a lawyer. The problem in those circumstances, of course, is that it can take quite a bit of time for trustee services to become involved, to appoint a trustee to handle your files, and to come to an understanding about how your files are managed. It can be quite overwhelming in those circumstances. And of course, you are leaving your clients vulnerable in those circumstances. You are leaving your own professional reputation vulnerable if some harm happens to your client's files. And you are leaving yourself open to malpractice claims if there is something that cannot be easily amended that occurs during that period. And so what LAWPRO would highly recommend people do, and what is in every lawyer's best interest, is to prepare for these kinds of eventualities in advance by finding their own replacement lawyer, not depending on someone appointed by the LSO, but someone that the lawyer knows would be a good replacement, would be able to quickly come to terms with the file, handles the same types of files. So I would like to put it to you, do you have any replacement lawyers in mind for your practice?
That's a very good question, Sean. And it's interesting. When I was asked to do this presentation, I was going back to my old files to figure out like a plan and memo, like in the eventuality of what happens. And I was looking at who I had appointed before. I'm assuming everyone over here who's participating has they may be involved in different areas of practices, from criminal law to estate law to business law to wills and estate. I have about 3 buddies, is what I call them. And because I do different areas of law, not everyone can do what I do as one person. So I have 3 different people that I have sort of in my mind that I would appoint in the eventuality if something did happen to me. Or I also look at it from the perspective is when we go on vacation, we always have to answer for files, whether we have a close-in or a trial matter. So usually I will ask a friend, hey, listen, can you please step in if something does need to happen? And I will transfer, pertinent information to that buddy. I think we should all look back. You should ask yourself when you're appointing your buddy is who should it be? Should it be someone like you, like because your clients have chosen you as your lawyer because of your personality, your skill sets, as well as what you're able to bring to the table for your client. So you should find a buddy in that same capacity, because the client is going to look beyond you and say, can my buddy help that client as well?
So on that topic, you mentioned how your buddy might be available to assist in terms of a vacation. If you were, for example, out of the country, you're unable to take action on a matter that suddenly arose and had immediate importance. You've already put in place some people who practice in the same area as you, who have already agreed to handle some of these emergency matters for you. A few other things to keep in mind, though, is that this isn't just for emergencies on a vacation or emergencies where you are ill. This can also assist with certain kind of temporary absences that arise throughout anyone's career. If, for example, you're going into parental leave, if you are going into a sabbatical for any reason, these kinds of people who you already have in place can provide you the kind of mental security to say, it'll be okay to go away. I can transfer some files to someone that I know that I've already prepared that my clients will be able to work with, and then I will be able to step back into my practice, and it doesn't mean that I have to shut everything down and restart it at a later date. That might not occur to you. You might have alternative arrangements, but just having that as a possibility provides people with a certain amount of peace of mind moving forward, that you know you have someone who is there to step in these circumstances. Now, one of the issues with stepping in, obviously, is they have to kind of come to terms with not only the files that you are representing, not only the clients that you are representing, but also how your office works. And so there are certain kind of technical matters that create barriers. So the big question is, how do people just access your computer? How do they access your files? Obviously, you're going to have everything password protected. So Anurag, just to kind of start off the top, how do you go about ensuring that people will be able to access that key information in your office? Do you keep passwords somewhere? Do you keep all of that data in a certain file? How do you go about doing that?
So for simple stuff, like for example, that are not where there's client confidentiality issues, things to access, for example, my accountant software, in the event of something did happen to me, we do have a password sheet for certain things. Now, unfortunately, and it depends on the personality of a lawyer, some of the pertinent information like bank and passwords or whatnot are in my head. So, and one of the things, it's what do you do with those? Where do you keep them? A suggestion is to keep them in a safe and give it to a what I call a super buddy or a family member, that in the eventualities that something did happen, is that person can access that safe and unlock the passwords for bank and probably some of the other Sean and I were talking yesterday about TerraView password, because I think that's a lot more very important password to keep to your chest. I don't think that password is necessary to be given to anyone in the eventuality of a death. And I think Sean, and when we're talking about it, that those kind of contingency matters can be taken care of by other lawyers too. In terms of access and data, it depends if you are a paper filing firm, like meaning you print everything and keep everything in hard copy, or you are a digital where you keep everything on the cloud or locally on your server, or you're mixed. I have a practice of scanning everything that gets printed, if anything does get printed, with a lot more remote sign-in that's happening. We're doing a lot more digital documentation, and everything is filed away in two places for me: on the cloud, this document management system that I use, as well as a local server. And organization is key, in the sense like, how are you organizing your clients? Like my client files are organized by last name, comma, first name. So every file for that client can be easily accessed on OneDrive. I know when I was younger and I worked at a law firm, that law firm had it done by matter number, which can sometimes be challenging to find if you don't know who that matter number relates to. So you must have a document system that can allow, if you don't have an assistant, another lawyer to come in to access the system. And if you are a digital person and you're pointing a buddy, make sure that other person that you're pointing is also technology savvy, because otherwise there will be other challenges in accessing that information.
So obviously, when a lawyer comes in, if they have access to your passwords, if they have access to your accounts, they can find some of the key information that is required to handle your matters. But there is some things that are going to be outside of your computer. Certainly, financial matters are going to be occurring through a bank, and providing someone with a banking password does not necessarily give them access to your bank accounts. And so there are some additional steps that need to be taken. One is, for example, putting together a power of attorney document that will appoint someone who is granted the proper authority to manage your professional affairs. So I just want to throw this to you, Anurag. How would you tell people to go about preparing powers of attorney documents in preparation of someone who might have to step in to manage your firm, your private practice?
So first of all, contact your bank representative. Um, Most lawyers, I assume, are dealing with commercial bankers, and commercial bankers are able to guide. Most commercial bankers can guide you to the process. If not, ask that person, the banker, what can you do to execute a power of attorney? Now, some banks, I've been told, want their own power of attorney executed in their format, appointing someone else. I reached out to my banker yesterday. I'm just waiting to hear back what the Bank of Nova Scotia does. So if you're dealing with a small business bank, and I know a lot of lawyers also deal with small business bank, and some of them may not understand the process. So just ask them, what can you do to appoint another lawyer to access the bank account, or as well as provide information of transactions that have been deposited? Because, you know, if you have an imminent closing, you want to make sure that the trust funds have been deposited, and to whose benefit they have been deposited from. You may need access to deposit slips, for example. A lot of banks scan those deposit slips that lawyers use when they deposit funds, trust funds particularly. So contact your bank. If you're having issues, ask the bank manager to ask someone else. A lot of the banks now have also professional banking services, in the sense that they've dedicated a team towards lawyers, accountants, dentists, and they will actually know the process of what to do, because their group is focusing only on lawyers.
So just to follow up on that, one thing that I learned recently, speaking with some of the trustee services employees at the LSO, speaking to some of the people who manage these circumstances, is that you really do need to speak to your specific branch manager for your bank. The people who are in charge of your specific accounts, the account managers and the branch managers, because the internal processes and the internal requirements and procedures are going to differ from branch to branch. You may have a power of attorney document that you believe should give someone the ability to access your banking records or your accounts, and in order to pay out any trustee funds that need to be paid out. But the branch manager for your bank might have a different process in place. They might require something else that you didn't even think of, and that can leave your replacement lawyer in a lurch. So just having that personal relationship with your account managers and your branch managers, letting them know who you are, who you have determined will be your replacement lawyer, and asking in advance what will they need, make sure that there aren't any of those hiccups along the way. Obviously, and when you are putting together any kind of power attorney documents, you can separate that out between any powers of attorney or living wills that you need to prepare for your personal matters, for your family matters, and that can be handled by someone, a family member that you have put in place to handle those things. And then you can have a replacement lawyer who has a separate power of attorney document only with powers that specifically apply to the practice and that they will need in order to manage that practice. So, Anurag, we were talking a bit about the organization of your files, about how you put information together so that it can be easily accessed, the naming of the files so that a new person can step in and understand it. So I just want to know, what kind of software do you use and organizational methods do you use in order to ensure that everything is easily accessed and retained while still being encrypted. Obviously, LawPRO is not going to endorse specific software programs, but if you have any suggestions or things that you use, please feel free to let everyone else know.
That's a very good question, Sean, because one of the challenges of running a small firm, unlike a large firms, as you know, have a lot more resources at their disposal. About 7 or 8 years ago, I started looking into document management systems, and it has been a challenge. And the challenge has been because a lot of those document management systems are geared towards the large firms, or the cost is high to implement. I used to house everything locally and then do a backup on the cloud. But one of the challenges we always have is just not the files that you're generating, whether you're creating an agreement or a pleading. It's also the email correspondences that are happening. I don't know how many people are sending faxes, correspondence, and what's been printed, but I find the managing emails and making sure that someone else can find that information is becoming a lot more challenging, because our inboxes gets cluttered in by so many different emails for different clients, or the same client for multiple projects. So I looked into a different document management system, and I know there's a couple out there. They're not perfect. Each one has their pros and cons, and you just have to find the one that works best for you. The key is making sure that someone who can come in can easily access the file, not just the documents that are being like agreements, purchase or sale for some business, but also the correspondence that's going on between you and the other lawyer, you and your client. In my situation, I deal with a lot of accountants, correspondence between the accountant and myself. Sometimes the brokers involved in the transaction too, so correspondence between the each of these are important, so you have to make sure they're all organized. I don't want to name a couple, anyone who's interested in knowing what system I use, they can reach out to me directly. I'd be more than happy to tell them which systems I've tried, which ones are working, and which ones I'm looking into as well.
Thanks, Anurag. And so we actually have a couple of questions here that I'm just going to pose to you now, because we have two people who have asked about what happens when you find it difficult to find a replacement lawyer, a buddy, as you described it. Some people obviously live in remote areas. They have very specific practices. They may not feel like they know of anyone who can step in and easily manage your files. One suggestion that I might have is just spending some time with your local law association and the meetings that occur there to find other local lawyers, and just that kind of networking in the same way that you would network for any other business opportunities. But do you have any suggestions for people in those circumstances? Because it obviously can be quite hard.
Well, if you don't have a buddy, like a friend that you could choose, look at opposing counsel on transactions you've worked with. If you had a good time, and if you feel like that person was competent enough and as well as reasonable, reach out to that person and ask that person to say, if something did happen to me, can I appoint you as the buddy? I think more people will be pleasantly shocked that just because you're opposing counsel on an opposite side of the file, that doesn't mean they would be there to step in. I've dealt with opposing counsel a couple of times, and that I've got to be friends with them too, or I've actually referred files to them as well. Because if that's, and I could appreciate if someone is in a remote area or doesn't have that many contacts, but that might be one opportunity. I assume the Law Society also may, I don't know if they have a system in place where they could, they could refer other lawyers to. That might be a resource to call. Or just randomly pick up the phone and call lawyers. Because I think more often than not, other people will be more than willing to step in.
Thanks. I know it is very hard to make friends in your 30s, and and older, and it's even harder to make legal buddies probably in your 30s and older. But it's something that we all need to try to do. Before we leave, Anurag, is there any other kind of technology or software processes that you would recommend that make it easier to organize your files in a way that someone else can step in?
Sure. So I was a I since the pandemic, I've been doing a lot more document signing for transactions, particularly corporate transactions. And I find even like things like virtual minute books, e-signing, instead of waiting for people to send you documents like paper documents, and sometimes they come into your office and you may forget to put them in the minute book or whatnot, look into the document management system. Organize your files because it is so much easier. Since I started my practice about 15 some odd years ago, everything's been digital. And when clients call me and ask me, can I have a copy of something? It just takes me 5 minutes to send it to them rather than trying to find a file, photocopy it, or scan it. Invest in the technology. You'll find that it's a lot easier and smoother to send documents back and forth and also to just retrieve them for your own purposes. Um, I think that's like, if you, the only thing I know we are having a hard time with is wills, because wills still have to be in a paper format, like stored, but doesn't mean you can't scan them and send them to clients for copies.
Excellent. Well, thank you, Anurag. That
Thank
was
you.
very helpful. I'd like to now pass it on to Greg, who's going to be talking specifically about selling your practice. So this is going to be the circumstances in which you do have some planning time allotted to leaving your practice. So Greg, if you can please turn on your camera here and we will, there we go. And Greg is going to be using a PowerPoint, so I'll turn it over to him. Thanks, Greg.
Good morning, folks. My name's Greg Kells. I've been a business broker now for 25 years. I own Sunbelt Business Brokers. All we do is sell businesses. Okay, we don't do real estate or anything else. We sell businesses. I have 30 offices across the country, and as a result, we sell a lot of businesses. So hopefully I can share some experiences, particularly related to selling law firms, that will be helpful to you. So whole whack of designations and all that stuff, which
Hi, Greg. Just to interrupt very briefly, I think we have a couple of people who can't hear you. If you could maybe just speak up a little bit. Sorry to interrupt, but we just want to make sure everyone's getting all of your information here.
All right, I'll speak up. Thank you. Okay. So when you're looking at selling a law firm, typically the firm is going to sell based on a multiple of seller's discretionary earnings or EBITDA. And of course, it's what's maintainable. People don't want to pay for peaks and valleys. They want a maintainable cash flow, and that's what they're buying. They pay for the past, but they buy for the future. And so knowing what the future looks like is important in terms of establishing value. What are they looking for? Consistent financial performance. You should have at least 3 years, preferably 5, of financial statements available. You want growing revenue, not shrinking. That means you need to decide when you're growing and when you're near a peak, not when you're coasting downhill, which is what we see too often. Management independent of ownership adds significant value. You know, if you're the value and you're retiring, what's the buyer purchasing? Skilled, well-trained, loyal employees, huge value. Diversified customer base. We see some firms where, 2 or 3 customers represent the bulk of the revenue. Well, that diminishes the value of the firm. People who are buying want a growth opportunity. They're not buying it for status quo. They are hoping that they can grow the business. Okay, so all those things influence what a buyer is going to pay. So well-established, documented systems and processes. You know, we just talked about turnover, et cetera, and dealing with the crisis situation. Well, if you've got good systems and processes, it adds value. They want a sustainable market position and brand recognition. Most of you think you have a great reputation. You might want to check and see what other people think, because sometimes your perception and the public's perception aren't the same. A strong referral base of happy clients adds value, and using effective technology makes a big difference. If you are using technology well, it adds value to your selling price. And I find that many law firms have no marketing programs. Geez, have a program, have some mechanism that you are using to grow your practice that you can document and communicate to a prospective buyer. They all influence what somebody will pay. So, what can you do in the short term? Well, get rid of some of the discretionary spending. That's the money you spend, which does not necessarily support the ongoing activities of the practice. Um, Adjust your salary or however you're taking pay to what is market rate, okay, so that the rest is reflected in your bottom line. Get rid of unnecessary costs. Resolve or settle any outstanding legal issues. Sorry. Pricing. A 5% increase in your pricing can represent a huge difference in the value of your practice. Get rid of unnecessary assets. Long-term contracts with clients are good. Avoid long-term commitments like major IT projects, vehicle leases, property leases with no break clause. Clean up and make your business look good. First impressions matter. Manage your working capital. I see a lot of law firms that do not manage uh, collections, and they're carrying way too much in receivables. Groom your management team. You want this business to be independent of you. So, what do you need? An office manager, a financial controller, somebody's looking after business development. Build, a saleable team. Keep your financials and your business plan up to date. A lot of people do a business plan, they put it on the shelf, and then they don't touch it for years. Well, that's useless. Ensure that your financials are produced quickly and filed promptly. Okay. Make sure you've handled any issues with CRA, licensing issues, HR policies and procedures. Have them in place. Make sure you're compliant. Health and safety records, licenses, etc. And get some tax planning advice. It'll help you. Don't sit there thinking about it and not doing anything. Okay? I see that over and over. People, yeah, I plan to retire in 3 to 5 years. What have you done about it? Well, I haven't actually started yet. Look at the changes COVID made to your financials. When we're doing valuations, we'll typically eliminate or reduce the weighting on unique circumstances like that. And there's going to be due diligence when you sell your practice. You might as well start assembling all of the materials that are going to be required now. Don't use rules of thumb to value your law practice. They're useless. Every practice is unique and it's different. They're buying the future, not the past. The past may be a guide to how they interpret potential futures. Okay, whoever buys the practice needs to have enough cash flow from it to pay themselves a living wage, reasonable, and enough excess cash flow to pay for the practice over a 3 to 5 year term. If the asking prices are outside that range, you won't have any buyers. Okay, buyers typically don't pay all cash, especially for professional service firms. Okay, you'll typically get 30% down from their equity. TD Bank has a professional service acquisition program. They will finance a significant chunk of the purchase price. Typical structure, 30% from the buyer, 30% from the bank, and you, the seller, finance 40%. Why? Because you're handing off a bunch of clients with no guarantee that those clients are going to continue to do business with the new owner. We never see an all cash deal. So there's a lot of differences in how the deals get structured depending on the nature of your practice, the buyer's cash situation, etc. Everybody's looking for a smooth transfer of files. I would say in the majority of cases, the seller actually wants to stay on and work with the buyer for anywhere from 6 months to 5 years, depending on theirs. And so they're going to ensure a smooth transition. Work in process. Whoa, this can be a big issue. I did one with a personal injury law firm. They had 20 million in work in process. Well, you look at this and say, yeah, how much of that will be realized over what period of time and what is the cost to get there? So 20 million drops down to something well under 10, okay? So they don't have repeat business. So their practice based on cash flow was not worth as much as somebody who has a lot of repeat clients. Litigation firms, yes, some repeat businesses, so it'll have a higher multiple than the personal injury firm, but not as high as people who will have a steady cash flow from repeat clients, okay? I want to give you a couple examples. I did a valuation last week for a law firm that is what I would call a generalist. They did real estate, wills, estates, tax, etc. They're in a smaller community, but they've got a stellar reputation. They're a top firm in their local area. When we finished the valuation for them, and this was to move the firm from the owner to a group inside the firm, it ended up, the valuation was roughly 70% of revenue. That is, they were doing a little over 2 million and the valuation ended up at a little over 1.4 million. Well, for a firm like that, that's reasonably consistent, okay? All the different types of firms are going to command different values, even if they got the same cash flow. Corporate law is great. Hey, repeat clients, steady, on and on going. Okay, it'll command a higher valuation. I caution you when you're looking at selling your business that culture fit is critically important. I sold a small 2-lawyer, bunch of staff firm that were specialists in a particular industry. In their industry, they were top dog. I sold them to a larger firm because the owner was looking at retiring. He wanted to work another 3 to 5 years with the acquiring firm. Well, the acquiring firm, process fanatics, everything documented. Everything had a process to it. Whereas the seller, he was an older guy in his 70s, been in practice for many years. Everything was, shoot from the hip and a different sort of approach for each client. Well, he liked the idea of process and admin gurus, and he thought that would make his life easier. So it sold a practice. He joins the larger firm. He was good at bringing in business. However, he could not change his work style. As a result, he's not following their practice. The end result, they're in conflict all the time. And I would call it a poor merger because of the culture fit. He couldn't change the way he did business, even though he wanted to. So you should get a valuation on your practice now, not wait until it's time, because the valuation is going to firstly let you know what it's worth, but also identify key value drivers for your practice. It'll ensure your information is current, up to date, because in doing a valuation, we do pretty much the same thing as you would do in due diligence. If you can measure it, you can manage it. If you don't measure and track things, they tend to get ignored. You'll learn what drives the value in your practice, and you'll get to know where you stand today, and you can put together a plan to get where you want to be. Set goals, with detailed steps to get there. So I recommend every law firm should periodically get a valuation just to know where they are. Clean up the balance sheet. We often see it's a bit of a mess. And get rid of the excess cash in the business. A lot of you just leave money in the business and it's sitting there. When you go to sell it, you got a problem getting it out. Okay. Also, be prepared to finance part of the transaction. You will get higher value as a result. Okay. Have an org chart. Have all the positions defined, who reports to who, what are the duties, etc. Have the right people in the positions. Get rid of staff that are underperforming, etc. Start focusing on how do I build value, not just how do I run the business. Your role as the owner, expand your operations, improve revenues and profits, and plan for future growth. So do a business plan. And I'm not talking about a huge elaborate document here. I don't care if it's point form and on one page, but at least know what your plan is. Update it regularly. Do an honest SWOT, that's strengths, weaknesses, opportunities, and threats. Do an honest appraisal of your own practice. If your practice is large enough, fire yourself. Get employees to replace you in your day-to-day job. Make yourself dispensable. I've tried to do that in my own practice. I'm talking to you from Florida right now, and I'm here for the month. And yet my business is running well. Delegate and empower your staff. Have an operations manual. Okay. Position-specific information, job description, duties, results expected. Know what your business is about. Why are you in business? What clients are you trying to serve? And why are you better than everybody else at serving those clients? Get your document, and this has been repeated by everyone, get your documentation current. Make sure that you've got all the records, minutes, financials, everything that you need. Clean up the office, clean up the operations. Now, you each received a book which LAWPRO sent out to you, I hope, in advance of this presentation. It's a book it's called Insider Tips on Selling Your Business in Canada. Read the book. It will help you significantly. Okay. Employee retention agreements and bonuses may be appropriate to make sure the staff are staying on with the new owner. How long are you willing to stay? By the way, we had that discussion about a critical event at another law firm that I'm helping right now, where the lawyer, it was a sole practitioner, he had a heart attack and was debilitated totally for 6 months. And then he went back to work on a reduced scale, but I got to tell you, he wasn't in the right mental frame of mind to be practicing. As a result, he had clients who missed critical dates because he wasn't looking after the files and he hadn't put someone else on. So make sure that you have a backup plan. Uh, Long-term lease with good terms is great, but have a break clause. The buyer may want to move the practice inside their facilities. Okay. Have a team that's helping you with this. You know, business broker is an important part of the team, but it's not the whole team. You need a transaction lawyer, an accountant, a business coach is useful, an exit planner who helps you with your financial plannings. What does the broker do? Well, we do financial recasting to figure out what your business is really making. Research and valuation, making sure you got proper documentation, evaluating your marketing programs. We do the buyer screening and matching. We do the business presentation. We draft the initial non-binding offers, manage the negotiations, come up with creative financing solutions that make deals work. And we don't do, but we manage the due diligence process and we manage the closing process. As you might guess, we work with a lot of lawyers because there's at least 2 lawyers involved in every transaction we do. How long does it take to sell your practice? Well, you can see the majority, 7 to 9 months, sometimes longer. Depends on where you are and what type of practice it is, etc. Our job as brokers is to confidentially sell your business. By the way, that's confidential. Your staff, you don't want them knowing you're doing this. Okay. Confidentially sell your business for the maximum amount in the shortest possible time frame with the least risk. There's a process for doing this. And I only got 20 minutes today, so I'm not going to walk you through every step of the process. Read the book you got. It's all documented. Okay. I presume you're also going to get a copy of this slide presentation. So why use us? Well, we specialize in selling small to medium size. Look, the deals we do are typically somewhere between $250,000 and 20 million. If they're over 50 million, I typically send them to a different firm because I don't think we're the best firm to do deals that size. We have national coverage, and international, by the way. I got a couple hundred offices in the US and others around the world. I don't own those. I only own the Canadian operation. But we find the best buyer. And of course, we've done this very often. And we got a proven track record of success. More than 98% of the time, the transactions work out well for both buyer and seller. These are win-win transactions. And we only get paid when we're successful. We don't charge ongoing fees to work with you. We charge an initial tiny valuation fee, and it is tiny. And we charge a success fee when we actually have accomplished the goals. You only get one chance to sell your business. You got to do it right. Okay. What's the rush? Okay. Quote, yeah. And unfortunately, I've seen this repeatedly, right? This is a common occurrence. We all wait too long to get ready. You know, you don't want to leave a mess to somebody behind you. So we work confidentially. we'll help you through this process. And I highly recommend you start the process early, get evaluation done, then work with the broker on what do I do to improve the value, reduce risk, etc., so that when you are ready, it becomes a much easier process and you'll get more for your business. I think I used my 20 minutes. Do read the book. Feel free to contact me anytime with whatever questions you may have. Email is the best way to reach me. I'm hard to get by phone. It's because we're busy, just like you.
Thank you so much, Greg, for presenting that information to us. Just as a reminder to everyone, the book that Greg referred to that contains a lot more information that elaborates on this presentation is contained in the program materials, which were distributed by email prior to this program. It can also be accessed through the link in the chat to the program materials, and it can also be accessed on our practicepro.ca/CPD page for this program. Now, Greg has kindly offered to allow us to share this PowerPoint as well, and so that will also be posted on the practicepro.ca/CPD program webpage, the same place where you will be able to find the video of this program starting next week if you want to review it that way. Greg, I think we are on track for time, so I'm actually going to put a couple of questions to you right now just to follow up on what you said. One individual asked to basically just clarify, during your presentation, you referred to a story of a firm that sold at 70% of revenue, and they just want you to clarify, is that referring to your billings when you talk about revenue, or is that their income after expenses?
No, that's billings, not
Okay.
income. Oh, geez. No, nobody would sell for 70% of their income.
All right. And one more question. Someone asked.
To be specific there. Their revenue's a little over 2 million, sold for a little over 1.4 million.
Thank you very much. And the second question is that in the context of the sale of a practice, how can value be ascribed to goodwill considering that the client has a constitutional right to choose any counsel? They can't be locked into a counsel for a long period of time. So if you could just elaborate on valuing goodwill when all the clients can walk away, what does that mean?
Well, I'm going to tell you how people mitigate that risk. Typically, when you're buying a law firm, yeah, you'll put a down payment, maybe 30%. You'll give them the other 40. The last 30% is going to be based on clients staying with the firm in the future. And so retaining clients becomes important. And typically the seller is staying on to make sure it's a smooth transition and the clients are retained by the acquiring firm.
Okay. Well, thank you so much, Greg. We're going to go now to our final speaker. Catherine Pretty from Lawyers Financial is going to talk to us about the financial instruments that you can prepare and look into in order to have that kind of preparation in place for either selling your business or emergency. So, Catherine, I turn it over to you.
Thanks, Sean. And it's been a pleasure hearing the other guest speakers. A lot of great insights. I've enjoyed watching, so thank you. And again, thank you everyone for joining us today. And what I will do is share a presentation and let me see. Just going to pull it up. There we go. Okay, so thank you everybody for joining in. I am a financial advisor from Lawyers Financial. We provide the financial advisory services through the Canadian Bar Insurance Association, and very pleased to be here again today. I was lucky enough to join last year. In addition to providing professional advisory services, a little bit of background information for everybody attending, I spent my career, 25, 30 years, leading companies at the executive level, operations, strategy, organizational development, as well as owning my own business. So I do have a lot of experience understanding at the sole proprietor level and at a larger corporate level all of the initiatives and hurdles that business owners go through. My business itself was actually providing strategic consulting to businesses on how to effectively manage and grow within their own operation. So that's just a little bit about me from Lawyers Financial. And for those of you who might not be aware, Lawyers Financial, we provide financial advisory services exclusively to the legal community. It's all we do. We service law firms, individuals, lawyers, judges, staff. We are what we like to call ourselves as experts within the legal community. And all of our advisory services from wealth, insurance, planning, defined benefit pension plans, they're all created around the needs of the lawyers. So rest assured that we do work very closely with the legal community, and it's our goal to understand quite closely all of your needs and what you would like to have in terms of financial advisory services. So what I'll do is I just shared, if anybody would like to ask me questions offline, you can certainly reach me. There's my link. You can hold up your phone right now and you can reach me through the link there. And that's how I can answer any of your more detailed questions. What I'll do is I'm going to share some insights and come at it from a little bit of a different angle. Just recently this year, so it's always nice to have really new relevant information to share. A survey was released in partnership with the Canadian Bar Association and Thomson Reuters Institute. If you look down on the left-hand corner of the screen, just out of convenience, I also shared a link to go directly to that study, the survey and report. So if anybody wants to do some nighttime reading, you can read the full report there. It is the inaugural State of the Canadian Law Firm Market report, and it's based off of about 330 lawyers and law firms. And I'm sharing this because there's some really tangible and newsworthy insights that come out of here that would impact lawyers and how you plan around your succession planning and how to navigate some of the business challenges. And one of the critical findings, and this is an excerpt out of their executive summary, is the law firm's definition of success does not always align with how you're measuring it. So there's a gap to what you think you're doing and where you would like to be. There's a gap to how you measure and plan for success. And of course, that brings opportunities and challenges as well. One of the largest insights, which is going to become very relevant in my discussion today with you, is two main insights. And this is a survey in terms of all the lawyers were asked the percentage degree or weighting of challenge that concerns lawyers and law firms. Ranked number 3 is managing mental health issues. This was a massive concern for lawyers. And out of the 330 participants in the study, it ranged from PCs, so individual solo practices, all the way up to the larger firms. So it did capture a wide assortment of audience in terms of the legal community. Ranked number 3 across everybody was managing the mental health issues. This is going to have a tangible effect on some of the strategies I'll share later. And the other one is attracting and retaining top talent. So nearly 60% weighting of concern. And I believe that was about number 5 or 6 on the list of the top concerns of lawyers. And that's really relevant because that lends itself to why we're here today. It's the long game to succession planning. It's being able to control how you leave your business, whether it be early for selling, profit, liquidation, or something a little bit more traditional where you control your exit plan peacefully and wind yourself out for retirement. But without attracting, retaining talent or having a good firm to sell at a high valuation, it's going to be very difficult to achieve those goals. And this is, again, these top 2 concerns are very relevant for law firms. So again, I encourage you click the link and you can do some reading, nighttime reading there. Succession planning. So we've been talking about that for the past hour. And again, it's around planned business continuity. So the ease of exiting yourself out and owning that strategy comfortably. There's the unplanned disruptions and events. So our role is to help identify those risks, which, there's two that I've just done there. And then there's actually a third, and that's sort of navigating the shifts during your business timeline or time horizon. And that's about being flexible. So being able to embrace business shifts that, while we didn't necessarily identify as a risk, or perhaps you didn't put in as a goal that you would like over the evolution of your business, it's being able to be flexible to adapt to change. Whether that be just 3 years down the road, unforeseen market insights or opportunities to change how you operate, we would still like to build a financial plan where you can still have the flexibility to do that. And another insight here, which is still relevant and lends itself to our conversation today, and this is actually from IBIS World. It's a 2024 report. Law firms are growing. So you've experienced a CAGR of growth at 0.7% if we look at the Canadian market. Overall, not industry specific, it's actually keeping on track with Canadian GDP and industry growth as a whole on average. So the key takeaway to this is you are living, breathing, and working in an industry. You're operating a business where you absolutely will feel the impact of having to either restructure, sell, liquidate, or effectively manage an event where you have to do some succession planning. So mergers and acquisition is also one of the reasons why we're seeing this growth within law firms across Canada. So nice little insight there. In terms of succession planning, here's some of the common themes impacting small business owners. And I know the other guest speakers have spoken a little bit about this and touched on it. These insights, they're real. They're number one, experiential from what we're managing here at Lawyers Financial, from my experience. And you will find, if you do track Business Development Canada, these are the key indicators that are impacting small business owners. Number one, confusing personal income from business revenue. That's a key factor. That's what I would call blurring the lines in terms of how to understand where you as the lawyer from a personal perspective need to operate, and where you as the entity, the lawyer, the firm, the enterprise, the holding company, the lines of distinction get blurred. Another common theme that impacts firms is not paying for business support and services, taking advantage of the deductible tax advantages that are available to you. And a little bit, that's sort of it's a theme that weaves itself in terms of you're expert at law in your field of law, but please, rely on the financial advisory services and your tax specialist to help guide you where you can take advantages and grow wealth and grow revenue within your company. Not maintaining cash reserves. Now, this is another insight. There's maintaining cash reserves, and then there's understanding when there's excess cash on the books within your organization, and how to balance both and optimize the excess cash within the organization. That's our role, to help give you the insights as to where to navigate with some tools and resources there. And not nurturing relationships with financial institutions. I really stress that Lawyers Financial, we are here pro bono. We provide consulting to the legal community. We don't charge, and we are here to give that advisory service to help you navigate your business. And the other key insight, which is one of the greatest impacts to lawyers and law firms, is not taking care of yourself. And as some of the insight I had shared earlier, mental health stresses is a major factor from an insurance and claims perspective, where we operate in the industry, the likelihood that individuals by retirement, and I'm just using a generalization depending on the type of claim, but generally speaking, over 60% of Canadians, you will file some type of a claim. Now, there's some deviations between male, female, actuarial stats there, but a good portion of us will file a claim before our retirement. So the importance of one, identifying that these risks are real and will be realized within our working careers, and the importance of taking care of ourselves in different means, both from a policy and risk perspective, and then of course from a health and lifestyle perspective. All of these are going to add a financial impact to your business. Now, here's the blur. So where we come in terms of understanding you, the lawyer, you, the firm, the small firm, the individual lawyer, the larger firm, is my role is to help you delineate or remove the blur. And when it comes to business, and specifically money, we're human. There is an emotional factor that triggers us, and especially around money. And when we are operating our own business, again, you are expert in your field of law, maybe not expert in running a business or expert in the financial aspects of that business. The emotional factors start kicking in. And what I've seen is the individual, the self, the owner tends to blur the lines with who they are as the company. And we're here to help delineate that, make sure you're wearing the right hat at the right time, and understand that you, the owner of the firm, you need to put that ownership hat on and make decisions that are less emotional based. And I know that's very difficult, but that's where we come in as a team to help guide you with, again, the fact-based insights and lay out some nice strategic plans for you, so that you feel confident that what you're investing in your company is for your company's good, and it's not the stress or anxiety that you should be holding for yourself and your family. What I've shared here, and this is really around now getting to what does succession planning look like for lawyers and law firms in terms of financial planning, managing risk, identifying what your goals are, and that's overlaid with a time horizon. What we do is we look at it in terms of stages, moving from left to right, and I know that there's a lot here, but we're only going to focus actually on 3 and 4, more on the right-hand side of the screen. But the approach and the strategy would be is when you start working and you enter your career and your job, you're really looking at your personal planning. That's the risk management. And of course, right away, you're thinking about your retirement planning and identifying goals. And that's really early on in your career. You know, life insurance, what we want to see is personal disability insurance come into play, and critical illness. Those are key must-haves. And the reason being, one, obviously, because we know statistically the claims rates of lawyers specifically that will be claiming throughout your professional lifetime. And two, an understanding that from a personal level, Canadians do not normally have deep pockets. So it's very difficult for an individual who's working to go 3 months without a paycheck before there's significant financial impact personally or to your home life. So we call that survival. That's number one. Then gradually over time, if things play out the way we like them to, you're in your 30s, your 40s, you've graduated to the invest stage of your life. And that's really where you are now contemplating your business continuation planning. So these are elements, and I will describe them in a little bit more detail, where you are now embracing the concepts around key person protection. So you're in a business, you rely on either yourself or a partner that is critical to the business and the revenue coming into your firm. You're starting to engage in conversations around buy-sell agreements. Retirement is coming closer. It's a little bit more tangible for you, and you're running your business. So now we have conversations around business overhead protection and executive benefit planning. These are all the tools that we have conversations and put into place, and policies, insurance policies that are put into place to help for the planned and unplanned events within your business. Hopefully, these are done. When we start talking about succession planning, where we'd like to be, by your mid-career, certainly is number 3 and 4. And that's where I'd like to focus more of today's time. And that's the tools needed for succession planning, because you've already identified when you want to leave, retirement, what your goals are, and what's critical to you and your family. So now we're really on the growth part of it. What does business succession planning look like? You want to get ahead of this conversation. As the other guest speakers have shared, you don't wait until you're 5 years close to retirement. Start dipping your toes into these conversations earlier. What does ownership transition look like? Are you going to sell? Will you be forced to liquidate? Are there concepts such as estate equalization between partners that you want to look at? Or is it a family firm? Maybe you have family that might step in and take it over, or parts of your family that will. What does the successor training look like? Buy-sell agreements, the funding for that. And then as well, looking at where you are in terms of the retirement and the income planning, and how your corporation plays into that role. So succession planning really evolves around number 3 here. And then of course, number 4, the estate planning. Now, estate planning can be both, we look at it in terms of you're deceased, or you're, so, and depending on, which scenario we're at, we want to make sure that you've had this conversation, that you have created a strategy around both. Again, estate equalization, the tax planning, is there any share redemptions between your partnership or the other directors within your corporation, trusts, and even philanthropy. So succession planning, we would walk you through, and when I say we, Lawyers Financial, myself, the teams, and collectively within the financial advisory industry, these are the strategies and approaches that you would be discussing. So this is really where your mindset should be for the sake of the conversation for today. Speaking specifically to some of the key solutions around this, some of the scenarios are, unplanned. So planning around unplanned events, and that's really just being smart, understanding the elements of risk, the probability that you will file claims, the probability, will you have to sell out earlier, and then just being mindful of what's available to you. So some of the key and very popular approaches and strategies would be business overhead expense. And what that means is it's a living and breathing insurance policy. It falls under the categorization of disability policy, but it would pay out on disability, injury, or illness, depending on the carrier. So different policies differ, but in terms of today's conversation at the highest level, the descriptions I'm giving and the concepts are accurate to explain each strategy. And what business overhead does is it pays out to your company, not to you personally, but to your company, funds. So when the owner of the company is injured, disabled, and can't work, there's funds there to help pay the fixed overhead costs of the operations. So it's a corporate policy. It pays to the company, salaries, rents, and a larger scope of expenses that your company must continue while you are recuperating due to high probability of being injured or sick. And I did put a link in. You can see the code there. So if you would like to see directly what some of the plans look like, I definitely welcome you guys to go click on that link there. And that's really to help make sure that the smooth operations of your company is not affected while the owner is recuperating. The second part, key person. And Key person insurance, again, here's a policy to help make sure that the talent and growth of the corporation remains whole while that key person is either disabled or has passed away. And then we have some other concepts in terms of buy-sell funding. So this is really where the concept of selling, planning a sale of your company, and we would fund that agreement through different life insurance policies. And they can be owned personally, they can be owned corporately as well. And we would help guide and work with your tax specialists on which is the most advantageous or appropriate for you to own these type of policies personally or corporately. Do they flow through the CDA account, and where there's benefits for your corporation to use excess cash on the books to take advantage of these. And then we get into a little bit more of the a little bit more complex strategies around your corporation actually owning wealth using excess cash that might be within the corporation, and funding your own retirement strategy, and then having that flow through to your estate on the personal level. So these are all concepts around retirement, maximizing the value of your estate, both while you're alive and enjoying the fruits of your labor through succession planning and operating your firm, and of course on death, where we can help maximize the death benefit payout where we can, in some instances tax-free to your beneficiaries. So that's kind of the at the highest level, a little bit around where we are in terms of providing a very robust set of solutions for lawyers, whether you're an individual, whether you're a small firm or a large firm. And I would walk you through the different stages. And in terms of succession planning, really we want to be looking forward to solidifying some of these policies and tactics, knowing that you're going to exit out in a specific time horizon. So I would encourage, we're here again, complimentary, we're here pro bono for all the legal community. You're welcome to book a meeting with me and our team at Lawyers Financial, and we do have a center of excellence of financial services that, again, we service exclusively only to the legal community. So.
Sorry, I was still muted there. Thank you so much, Catherine. And I believe you're taking us right near to the end of our time. And thankfully, we were able to answer a lot of the questions during the program, which is helpful because we don't have a lot of time for questions right now. But actually, I do have one question. And Greg, if you are available to turn on your camera and answer one question very briefly here, I would like to put this to Greg. Greg, if you're there, the question is, your presentation, does that only apply to selling the firm's business as a whole? What would be different if you were trying to sell just one lawyer's business within a firm?
There isn't much difference. However, calculating the value of the cash flow would be a bit different, okay? Because a lot of the expenses are covered by the firm. So yeah, the valuation may end up different, but it's the same process.
All right. Thank you, Greg. So just a little wrap up here. I'd like to thank again everyone who joined us today for this program. Thank you to our excellent speakers, and thank you to everyone at the TLA, Sandra, Deirdre, and Precious for organizing this program, and of course, Joan, who introduced it. There is going to be a link to a survey put at the bottom of the chat. Please click on the link and fill out the survey. It really helps us put these programs together. It helps us know what kind of content you like to see, what is helpful, what is less helpful, and help us focus this in the future to provide the best kinds of programs we can for you. As mentioned previously, this is worth 90 minutes of professionalism CPD and 1 risk management credit for your LAWPRO insurance in the future. And you can also find this program, as well as the program materials, including Greg's book, as well as the PDFs for both Greg's and Catherine's presentations at practicepro.ca/CPD. If you click on this particular program, the video will be up next week. It will take time to process that. We will also be sending out an email follow-up that will have the 2 PowerPoint presentations for your records. Thank you again, and I hope you join us for our next program coming up in May, and that is going to be on real estate. And so keep an eye out for more information on that. Thank you very much.